Good afternoon, everyone. I'm Philip Bremer from Minter Ellison Rudd Watts. I have the great pleasure of introducing the panellists for the afternoon session, as I understand it, the final session. So we have the primary panellist, Rohit Singhal, and Rohit is the Chief Executive Officer of Masin. He has over 25 years of international experience involving construction, contract disputes, expert testimony, and project management. He has extensive expert arbitration and appointment experience, and he has been appointed as an expert witness more than 50 times on delay, technical and quantum matters for construction arbitration. He has also presented and published numerous articles and undertaken several speaking engagements. He's also been awarded the prestigious Outstanding Expert of the Year award in 2019 by the International Arbitrators and Experts in Engineering Sector, UAE. The other panellist is Ratan Singh, also from India. Ratan is a senior associate and an international arbitration practitioner based in New Delhi. He is one of the leading arbitrators and counsels appointed engaged in complex high-value construction, engineering and commercial litigation and arbitration. He specialises in construction, engineering, infrastructure, mining, joint venture, franchisee, sale of goods and general commercial and civil disputes. So welcome to both of you, and I will hand it over to you. We'll very much look forward to this session and hearing what you have to say. Thank you.
Thank you and good afternoon, everyone. My name is Rohit. It's a pleasure to speak to you. Along with me, I have my fellow panelist, Mr. Ratan Singh, who is a senior advocate. Our third panelist, Mr. Shourav Lahiri, some technical problems are there, but I presume he's going to join very soon. Our topic of discussion, which we are going to talk about, is construction arbitrations in India, the recent trends and changes. India is a huge country, as all of you know, a country of exponential growth in terms of population, urbanization, and has been seeing a constant rise in disposable income. The construction and infrastructure sector plays a key role in the development of India and its economy. The construction sector accounts for almost 9% of India's GDP, which is approximately $2.2 trillion, and is quite significant, and is second only to the agriculture sector in terms of the total contribution to the GDP. However, construction sector is little fragmented, with only a handful of major players in the areas of real estate and infrastructure construction. And definitely, there is a need for more and more contractors and stakeholders to come and take part in the Indian construction sector and infrastructure sector. As India strides towards better developed nation status, we definitely need more of such kind of players. With the increased demand from real estate and infrastructure projects, the Indian construction sector is projected to be the third largest construction market in the world by 2025. The Indian construction market looks promising, opening various avenues for all stakeholders, including international construction companies, financing institutions, and supply chain. Few instances reflecting these promises are: the Indian real estate sector alone attracted $5 billion in institutional investments in the year 2020. I think the slide needs to be projected. Thank you. The government of India plans to spend $1.4 trillion on infrastructure during the year 2019 till 2023. So another 2 years, already a large chunk of this value is under investment, and more of it is being seen. And this is done to ensure sustainable development of the country. The government of India has suggested investment of $750 billion for railways infrastructure for the period 2018 to 30. So you can see the figures, they are quite magnanimous, and that what gives you the quantum and extent of the Indian infrastructure and construction sector. With the construction industry increasing in size, disputes in this sector are burgeoning. Traditionally, parties used to go to the courts as the forum for resolution of their disputes, but with the courts being overburdened with large volume of cases, players in the construction industry have increasingly been turning to arbitration over the past decade or two. As a result, and as can be seen in many other common law jurisdictions, the leading court decisions in the area of arbitrations are often in construction matters. While arbitration is becoming more common as the method chosen to resolve disputes in India, unlike many other countries, ad hoc arbitration is still dominant form of arbitration, and institutional arbitration is starting to catch up, but still has long way to go. Recent changes in the applicable legislation and the courts pushing for the arbitration to be formalized and institutionalized, with bodies being formed to provide oversight to arbitration institution, and arbitration is one of the areas which is now giving more impetus towards institutional arbitrations. So that's what the first slide is basically now giving you an idea of what is the size of the Indian infrastructure sector. And we are talking of spending of approximately $1.4 trillion in coming 2 to 2.5 years. We call it as a 5-year plan for the government, and $1.4 trillion has been allocated towards construction and infrastructure sector. Can I have the next slide, please? Now let's talk about the legislation and what are the various acts which govern the arbitration and conciliation in India. As I have already explained you, given the relative lack of institutional arbitration in construction disputes in India is often carried out under the aegis of the applicable arbitration legislation, which we call the Arbitration and Conciliation Act 1996. Recent amendments to the Arbitration Act in 2015 and 2019 put arbitration law and practice in India at the forefront of many other nations. Though the report card of the most recent amendment, which was done recently as in March 2021, is mixed. So I'll give you some examples of how the legislation on Arbitration and Conciliation Act functions in India. For instance, the 2015 amendment to the original act, which the original act was issued in the year 1996. After that, in 2015, the amendment has taken place. As per the amendment, the amendment added a time limit for the issuance of arbitral awards of 12 months from the date the arbitral tribunal enters upon the reference. While this sort of time limit is not unusual in arbitration legislation in civil law jurisdictions, it is relatively uncommon in common law jurisdictions. The legislature in India has therefore signaled through this amendment that it wants arbitral tribunals to get on with it, make tribunals more efficient in writing awards, and reduce the scope for delaying tactics by recalcitrant respondents. However, in practice, this has had a downside, as a 12-month period, even if extended to 18 months, which is extension is possible by another 6 months. So even if the total period is extended to 18 months, it is extremely short for construction arbitrations, which everybody of you know tends to be quite heavy in terms of evidence and complex to the facts. As you may all be aware, even the scheduling of the hearing in a construction arbitration takes more than 12 months from the time the tribunal enters onto the reference, let alone the time needed for final arguments. And let me clarify, in India, like what you see in most of the arbitrations, there are no closing submissions. The closing submissions are generally done through oral arguments, and that's what is called final arguments. So therefore, the subsequent writing of the awards is a challenge when it comes to a period of allocation which is given as 12 months. The result has been that relatively inadequately reasoned final awards, which is primarily because of the insufficient time which has been there, has been seen quite a lot in recent days. A subsequent amendment in 2019, which I explain as further, seeks to address this issue which the construction sector and construction arbitrations has been facing. This amendment of 2019 added a fast-track procedure to have disputes resolved with the award being required to be made within a period of 6 months from the date the arbitral tribunal enters upon the reference. This sort of procedure is commonplace in institutional arbitration rules internationally, but is not usually incorporated into the seats arbitration legislation, which has been done by the 2019 amendment. The 2019 amendment also expressly stated that the institution of a challenge to an award does not provide an automatic stay on the execution of the award. A party would need to make a separate application in this regard. And generally, the institution of challenge could be the courts which are there, which could be High Court or Supreme Court of India. Prior to this, there was a considerable amount of uncertainty and therefore a lot of litigation in this area. However, in what is widely considered a retrograde step, the 2021 amendment, which has come after 2019 amendment to this act, allows the court to unconditionally stay enforcement of an award if it is satisfied that there is a prima facie evidence that the arbitration agreement or the award were induced by fraud or corruption. But of course, unfortunately, neither of the two concepts are very clearly defined, and a very wide discretion, which is to have retrospective effect dating back to 2015, is seen. One can expect allegations of fraud and corruption to be front and center of numerous applications resisting enforcement of awards going forward. Now, March 2021, this amendment has come in, and with this amendment, there is this provision of an application being raised by the parties to get a stay on the enforcement of the award. So we are expecting that a lot of such applications will be coming in this. Another interesting aspect of the 2015 amendment was the statutory inclusion of the traffic light test for disclosure by arbitrators of conflict of interest, first introduced by the IBA rules on conflict of interest in international arbitration, including the statutory prohibition of appointment of tribunal members where factors fall within the non-waivable red list type of matters. This statutory incorporation of the IBA guidelines into national legislation makes India unique in the international arbitration world, as in most international arbitrations and seats, the IBA rules are generally taken to be guidance and not binding. But that's what has been done by the 2015 amendment to the Conciliation Act of 1996. This statutory control has made a significant impact on the construction arbitrations within India, which in the main are primarily against the state or national government entities whose standard form of contracts for construction works entitle the state or government entity to appoint an officer from the same entity as the sole or a party appointed arbitrator, a practice which is now outlawed. So a few years back, what used to be the biggest problem in construction disputes is that one of the officers of one of the state or national authority used to be a party appointed arbitrator or used to be the sole arbitrator. So there was a lot of criticism on such kind of terms and conditions which were there in the government contracts, but this has been modified by the 2015 amendment. Now, another set of amendments were issued in the year 2019, which was seeking to reduce the role of the courts in appointment of arbitrators by delegating the role to an arbitral institution. The amendment also introduced the formation of the Arbitration Council of India to promote and regulate arbitration institutions. The 2019 amendment also gave some relaxation to the stipulation of the 12 months period, which I just talked about, from reference to the award in international commercial arbitrations by encouraging tribunals to keep to this time limit, but not making it mandatory. In addition to the power to grant an unconditional stay of enforcement in circumstances of fraud and corruption, as I had just told you, the 2021 amendment that also specified minimum qualifications for the arbitrators. The 2021 amendments leaves the regulation of arbitrators to be carried out by this new institution called Arbitration Council of India. These qualifications were seen as preventing foreign arbitrators from being appointed in Indian arbitration. However, with the removal of the 8th schedule and what we call as Section 43J of 2019 amendment, the legislature has now leveled the playing field for arbitrators, both domestic and foreign. So I think that was the first two slides give you an idea about what is the extent and size of the construction and infrastructure sector in India. And the next slide, which I've just explained, gives you an idea about what is the legislation governing the arbitration and conciliation in Indian jurisdiction. Now I'll invite my other panelists to talk further about this issue. Can we have the next slide, please? I think Mr. Shourav Lahiri from Atkin Chambers has also joined us. The next slide is basically going to talk to you about or tell you about the influence of Supreme Court on Indian construction arbitrations. And I request Mr. Ratan Singh, a senior advocate, to talk about it. Mr. Ratan, over to you. Thank you.
Thank you, Rohit. Good afternoon, good morning, good evening. Before I make my presentation, one correction. Moderator introduced me as senior associate, which Rohit sought to correct. I'm senior advocate based out of Delhi. I'm founder and chairman of Society of Construction Law India, and I'm also director of CIR India. To preempt three very regularly asked questions about Indian jurisdiction, that whether we teach construction law in India in law colleges and engineering colleges. Second, do we have technology and construction courts in India like UK and other jurisdictions? And do we have security of payment legislations like Housing Grants Act, SIPA in Malaysia, and so on and so forth? Answer to all the three, ladies and gentlemen, is no. So now, from here on, I go on to make my presentation. As Rohit told us that 2015 amendment to the Arbitration and Conciliation Act of 1996 brought about substantive changes in the arbitration legislation in India. If we look at the arbitration regime in India, there are three eras or three regimes, we can call it. One is 1940 to 1996. In 1996, we adopted ancestral model law. And in fact, most of our provision sections of our legislation were pari-materia, with identically worded with the ancestral model law. So that is one regime. Another regime is the 1996 to 2015. And this period would be taken as a mixed bag, where we had some good judgments, but this period is more known for some of the aberrations which came in the form of judgments like Bhatia International, which said that the part 2 of our Indian legislation, which deals with foreign awards and the so on and so forth, that would also apply. So with regard to this, the Bhatia International judgment had said the part 1, which deals with domestic arbitration and domestic award, would also deal with foreign arbitrations and foreign award. And we had some other judgments like ONGC versus Saw Pipes, which had enlarged the scope of interference by the courts while dealing with setting aside proceedings. 2015, on the recommendation of 246th Law Commission's report, substantive changes were made in the arbitration legislation in India. And although changes have been referred to very aptly by Rohit, so I need not go into that. I'll deal with, but this 2015 is a year which would be remembered in Indian arbitration history, for our Indian arbitration history, for two reasons. One, that it brought about substantive positive changes. Another is that this is the time when Indian Supreme Court and other high courts started coming out with very progressive and positive judgments. And this is where I come in here. And judgments have been very forward-looking judgments. Now, one judgment which would attract everybody's attention, particularly for the international audiences, PASL Wine Solutions versus GE Power Limited, where Indian Supreme Court has held that Indian parties are free to select an arbitration seat outside India. Earlier, there were conflict of opinions amongst various high courts, where high courts, most of the high courts had said Indian parties are bound to follow the Indian laws and they cannot go outside India to have their arbitration. Now, this issue has been settled once for all by the Supreme Court of India. That is one very interesting judgment and has been appreciated all across the globe. Another very important judgment, again for international audience, international participants, would be the judgment of Amazon versus Future Retail, where an award, emergency arbitration award from Singapore, was upheld and enforced in India. In fact, just before this judgment came about, I had argued a matter that was called J. Yusin versus Yushin. And there again, we had the same issue. In that case, I was doing one arbitration in Tokyo under the rules of JCAA, and there was an emergency arbitration order, interim order, which was challenged in Indian court. And this matter was taken up to Supreme Court. And Supreme Court had refused to interfere with that. And now we have, but in the Supreme Court, what was challenged was the order of the Delhi High Court Division Bench. So Supreme Court did not have occasion to go into the merit of this entire issue. And that judgment, that case I had argued from Delhi High Court up to Supreme Court. But Amazon versus Future Retail had settled the law in India, and which says that the emergency arbitration awards, the orders are enforceable in India. Another very interesting judgment, again, these are all post-2015, is Brahmani River Pellets versus Kamachi Industrial Limited. Again, I had argued this case in Supreme Court. There, in that case, there was no mention of seat in the arbitration clause. What was written was the venue. Now, dispute was whether venue would be merely venue or that will also be treated as seat. I had argued before Supreme Court that it should be treated as this is akin to seat because there is no other intention of the parties going by the arbitration agreement. So Supreme Court dealt with this issue and held that in that case, venue would be seat, or for that, this is a law of land. Venue would be seat in the absence of any contrary intention. So this Brahmani River Pellets versus Kamachi Industrial Limited, and has been again followed in many subsequent judgments of Supreme Court. There's yet another interesting judgment of TRF versus Energo judgment of Supreme Court. These are again, as I said earlier, these are all post-2015 judgment. As Rohit talked about, unilateral appointments have been barred, prohibited under 2015 amendment. Issue in that case was whether a particular person who is a designated arbitrator under the arbitration agreement can appoint somebody else if he is debarred. Can he appoint somebody else, and whether that somebody else will be, appointment of that somebody else will be valid appointment. Supreme Court in TRF versus Energo said no. If a person is incapacitated by the operation of law, in that case, any of his appointees would also be incapacitated, and he or she cannot sit as arbitrator. The TRF judgment again has been followed in many other judgments. That is yet another important judgment one can really look at. One issue which was more like a vexed issue in Indian jurisdiction was whether allegations of fraud made in any arbitration proceedings, and whether there, as and when there is allegation of fraud, whether it vitiates arbitration agreement and whether disputes would be arbitrable or not. Supreme Court had occasion to deal with this issue as well in Rashid Raza versus Shadaf Akhtar. Rashid Raza versus Shadaf Akhtar. And this judgment again says simple allegation of fraud will not vitiate the arbitration agreement. And it says that if allegation of fraud is inter parties, that is not going to vitiate the arbitration agreement. Otherwise, there was tendency in some cases where parties would raise issue of fraud or nothing to derail the whole process of arbitration. That is again gone. Yet another judgment is very interesting judgment, and that judgment is Delhi Metro judgment. Delhi Metro judgment, which is a 2021 judgment. But before I come to Delhi Metro, there is a judgment of Supreme Court where question was where awards can be modified by the courts while dealing with the annulment proceeding. And Supreme Court had occasion to deal with this issue earlier as well, whether arbitral awards can be modified while deciding the setting aside proceeding. Supreme Court in this case very categorically said that going by the provisions we have in India, and that provision is Section 34 of Arbitration Conciliation Act, courts cannot modify the award, and only option available to court is that court has to set aside the arbitration proceeding, arbitration award, leaving the parties to avail their own remedies. And another issue